Welcome to Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. This week, we examine the precarious state of the rule of law. In the second half of our show, we'll be joined by Frank Buckley, author of The Once and Future King, The Rise of Crown Government in America. But first up is Sam Kazman, General Counsel at the Competitive Enterprise Institute and one of the lead attorneys in both of the Obamacare lawsuits recently in the news. Sam, welcome to the show.
Hi, nice to be here.
Sam, I brought you on for a couple of reasons. The first is to catch us up on some of the Obamacare litigation that seems to be heading toward the Supreme Court, but then to discuss its wider impact on the law. Why don't you start us out with some of the recent Halbig rulings and King rulings on Obamacare and remind us where we are?
Sure. These are all cases that were filed after what I call the first wave of Obamacare litigation, the one that ended, I think, in June 2012. There are four cases that really focus on what sounds like a very dry and technical provision in the Obamacare statute that involves the fact that the statute as written indicates federal subsidies for the purchase of health care insurance are only to go to those states that have set up their own health insurance exchanges.
So the refusing states would not get any subsidies.
Right. And the thinking here was, one, Congress could not constitutionally order states to set up their own exchanges because that involves commandeering of state legislatures. It's a violation of the Constitution.
They can only bribe them.
They can only bribe them. And so they figured no state in its right mind would, in fact, turn down the subsidies.
Now, Congress has been bribing the states for years to gain powers, haven't they? And everything from highway programs to Medicaid. Isn't this a standard practice?
That's right. Now, usually the states take those bribes. Sometimes, though, they do not. And that possibly is becoming a more prevalent trend. That remains to be seen. But this was patterned after many of those.
So it wasn't an original idea?
No.
And why are there four lawsuits that are chasing this?
Two states have filed their, I should explain what the lawsuit is over. So you had Congress draws this distinction in the statute between states that set up their own exchanges. If a state does not set it up, if a state acts as you call it, and as we've called it in the past, as a refusing state, then the feds themselves can step in and set up an exchange. But the subsidies would not flow to that state.
And is this just one paragraph in the law that says this? Or?
Well, it starts in one paragraph, but the government is essentially arguing that that distinction is just pretty much of a typo. Congress didn't intend it or something like that. So speaking in terms of where it shows up in the statute, at the D.C. Court of Appeals hearing in one of our cases, one of the judges asked the government attorney pretty much as soon as he had stood up, do you know how many times that phrase established by the state appears in the statute? And the government attorney basically says, several, Your Honor. And the judge says, do you know how many? It appears 7 times. I counted that myself.
Wow.
That was a wow moment. And so in no sense, the implication of that exchange was not a friendliest of exchanges. This was not a glitch. This is in the statute, and it's in there a number of times.
These four cases all hinge on that. And you said two have been filed by the states?
So 2 states have filed their own challenges. One is the state of Oklahoma. One is the state of Indiana. And each of those are pending in different district courts, federal district courts around the country. We filed one in May of 2013 here in D.C.
And we means?
CEI itself is both coordinating and funding this case, the one that was filed in D.C., and another case I'm about to describe. It was filed by Mike Carvin of the law firm Jones Day. Mike Carvin is one fantastic litigator. He actually argued half of that Obamacare litigation before the Supreme Court the first time around. And it was on behalf of several individual plaintiffs and also several small employers from around the country, arguing that the IRS passed a regulation supposedly to implement the exchange provision, the subsidy provision. And that regulation said subsidies will go to everyone. That's what the IRS
So the
did.
complaint is that the IRS overstepped its bounds and is making up law by offering subsidies to people that are not eligible under the statute.
Exactly. Now, the reason this matters for the employers is because attached to those subsidies are some pretty stringent mandates and penalties. So if you're an employer and if you have employees who start to buy insurance on these exchanges because your own insurance offerings don't meet the Obamacare statutes, you can be in for some walloping.
So that's who's being
penalties.
harmed. That's who actually becomes the plaintiff, because you can't be a plaintiff if you're not being harmed.
You have to be harmed. Now, for the individual plaintiffs, we can get into a pretty technical discussion of why are they in fact harmed.
No, let's not do that.
Let's not do that. But let's leave it with the fact that the D.C. Circuit agreed with the lower court that, in fact, one of our individual plaintiffs did suffer harm. Not huge in magnitude. We'd argue that it was huge in terms of the absolute hassle of having to buy a product that this person did not want to buy, especially through these wonderfully designed Obamacare health websites. That's the one entity that was, in fact, found to have definite injury in our case.
So that's one D.C. Circuit ruling, which is one step before the Supreme Court. But there was another case in another court that went the other way.
So about several months after we filed the D.C. Circuit case, we decided to file another case in another circuit, namely the Fourth Circuit, was filed in Richmond, because the judge in the D.C. case simply was not moving on the case, and we wanted a backup case where the chances of her getting stuck in the judicial system just stalled there might not be as great. And in fact, both cases have moved, and they moved relatively rapidly. So of the four cases on this issue, the two that we CEI are involved in, one is the Halbig case in the D.C. Circuit. The other is the King case down in the Fourth Circuit. They were both decided, and they were actually decided within less than 2 hours of each other. So you had a circuit split.
You think they were communicating with each other?
I think it was more than coincidence, but I won't get into that. However, we do get a lot of questions. Has circuits ever split this quickly? And of course, here, it's not just splitting quickly, but splitting in litigation involving the same attorneys. And so we've asked the folks at the Guinness Book of Records to look into that, and we're waiting to hear back.
Does this automatically mean a Supreme Court review?
No, it does not.
So what happens next?
The government first announced that the subsidies would remain in effect for the time being. And in fact, in the D.C. Circuit, the court, I believe, expressly allowed for a stay of its ruling until further appeal. And the government, Justice Department announced it would be seeking on-bank reconsideration. That's when the full circuit takes up a case decided by one of its three judge
So they get
panels.
another at-bat at the D.C. Circuit.
Yes, they do. They have not yet filed for that. That's what they said they would do. And at this point, the possibilities for us in the King case, where we lost, are either to seek en banc rehearing there or to go to the Supreme Court. And frankly, no decision's been made yet.
Is not delay beneficial to the administration, because the more people they get used to the subsidies, the harder it's going to be to reverse it politically?
In that sense, it is correct, which is one reason we wanted the cases to move forward quickly. It becomes more entrenched. There's at least this appearance that it's more difficult to reverse things.
Once people get used to something, it's hard to take it away.
Absolutely.
So this is likely to go to the Supreme Court, but if it does, it'll be a year, 2 years before it gets decided?
That's possible. It's also possible that if we were to seek Supreme Court review of the Fourth Circuit decision, it could move quickly. And the reason I say it could move quickly is that, in fact, the judges appear to realize that this is a case that should be decided sooner rather than later. And that's evidenced by the fact that in both the D.C. Circuit and in the Fourth Circuit, we got some very fast briefing schedules, a very fast argument after those briefs were in, and a relatively quick decision. So we asked for expedition, speeding, accelerating the case in both circuits. That's what we got. If it goes to the Supreme Court, I think those same factors will play a role.
But at the very least, it'll be after the 2014 midterm elections.
Before you have a decision.
Correct.
I think that's likely.
That's a safe bet. So, Sam, what was the reasoning behind the two decisions, and in fact, opposite reasoning in both cases?
Okay, the basic question was whether the statute was clear on its face or whether it was ambiguous. And if a court finds a statute is ambiguous...
And that happens.
It happens quite often,
okay.
Yeah. If a court finds that a statute is ambiguous, the next question is the agency that is implementing that law, is it construing, is it interpreting that statute in a reasonable manner? So a finding of ambiguity opens the door to the federal judges to give deference to the agency. And usually deference to an agency means a lot of deference to an agency.
And one man's reason is another man's lunacy, so really anything goes at that point.
That's correct. That's correct. Now, the D.C. Circuit case found that it was not ambiguous.
Plain on the face of it.
That's right. But they said even if it is ambiguous and we start fishing around for the intention of Congress, we still come out to the very same place. Namely, you need to show a high degree of conflict between different provisions in order to override the plain language of the statute. And it said, in this case, we just don't find that high degree of conflict. And so we're going to stick basically with what the statute
plain language
appears to, yeah.
And I think in legal theory, sticking to the plain language of the law is called textualism.
Usually, though, that term is defined different ways by different people, but I think done correctly, it does pay some attention to what Congress may have meant. Congressional intent is not ruled as being totally out of bounds. You have language as primary, congressional intent does play a role. Now, one argument regarding congressional intent is the claim that our opponents have made and the claim that lots of commentators made even before these cases came to this point, and certainly now after, is that, the Congress wanted everyone to have subsidies. That's the overriding congressional intent. One metaphor that's been used widely, and I'd like to get back to, is the notion of Obamacare is a three-legged stool, and the three legs are one, community ratings, so everyone gets pretty much insurance.
Same deal, no matter how sick they are.
Secondly, everyone has to get insurance. And third, subsidies. And so the argument is you knock any of these legs out of the stool and it collapses. And so Congress wanted to give everyone subsidies, and if you rule the other way, you've destroyed Obamacare.
And arguing that Congress intended this to collapse as a step to single payer is a tough argument to make, even if many people believe that.
I think that's correct. But the main thing is, it's easy to mutter the words, what did Congress intend? When you've got a statute, especially a statute as huge as this, I think it runs over 2,000 pages, passed under the most swamp-like of conditions as far as knowing what was going on, there were lots of congressional intentions.
What is this? 535 people there. What does congressional intent even mean?
That's right. And even if you could come up with a few congressional intentions, everyone on the Hill, everyone in Congress had to filter those intentions through the whole political process of log rolling, compromise, and even doing it constitutionally. And so, in our view, there were some specific reasons why Congress chose the manner it chose, namely subsidies only to the states that set up their own exchanges. And part of that was to get some key votes that otherwise would have resulted in the filibuster.
But the argument also, and I think Jonathan Gruber from MIT made this argument, and they've got him on tape now, it's been circulating in the last week or so, is that this was really intended as a threat to the state. Hey, you better set up that exchange or your people are going to get screwed out of their subsidies.
Right. Now, Jonathan Gruber's position here is pretty interesting, and it's gotten more interesting in the last few days. Gruber is widely viewed, MIT, is an MIT professor. MIT has got a nice puffing press release touting him as the architect. He's Mr. Mandate, in that he actually helped design the three-legged stool metaphor. And so he was on record as saying, our arguments are just based on a typo, a glitch. There was no such intention.
He even called it.
Well, Spico is how he referred to the recently unearthed
the smoking gun
2.5-year-old video of him saying just the opposite.
Yeah.
But, for starters, those who call this a glitch or a typo, in our view, one, they don't know much about the law, and two, they don't know much about typography. When it comes to Gruber, he's the architect of the law, so I can't say the first part of that against him. But now to see him calling what he said both in that 2.5-year-old videotape presentation and in another one just a few weeks later as two Spicos, he's talking about taking a 5 or 6 sentence block of text and claiming, oops, I didn't mean to say that.
What's wrong with the ironclad defense, which is exactly the one that the president used, which was, I was lying to you before, but now I'm telling you the truth?
It's rarely stated that honestly. If it were stated that honestly, I think we could respect it. But essentially, a whole lot of what's happened under Obamacare goes totally contrary to what we were promised.
But we're all grown-ups. We all understand this is politics. We all understand that politicians lie, and we understand that experts lie, and they'll do and say whatever they need to do to get their way. This is the world we live in. which also means that statutes can be interpreted any way that the current administration pleases.
Well, in that case, really what happens is that you've destroyed the function of Congress. And in one sense, I've got to say, after all the politicking and yakking about these cases, it's nice for me to see that it's the framers who got the last word, at least in the D.C. Circuit case. It comes back to the fact that Congress does lots of stuff, but the one thing we can be sure of are the things it writes down, the text of the statute. That's the one thing that is definite. And sticking to that text, I think, rather than letting agencies run loose, means you keep that separation of powers between Congress on the one hand, which writes the laws, and the administration and its agencies on the other, which implements those laws. You do not allow agencies to start rewriting the laws.
But it seems to be happening. In fact, you say that Congress's function is destroyed. I think the president's argument is Congress has destroyed its own function through gridlock. And so he's able to rule by decree. He's got his pen and his phone. There's a lot that's going on there. And in fact, John Boehner has started yet another lawsuit to try to get Congress's function back. Is that not all related to what's going on here?
In one certain sense, it is. And, to what extent Boehner's lawsuit ties into the phenomena we see is an interesting one. In one sense, I wish him luck with his lawsuit. I think case law goes two different ways on the question of congressional standing to go after the president. What's unique in Boehner's case is that I believe he already has a resolution from the House of Representatives authorizing the suit. And so that's a pretty unusual circumstance, because it's not just Boehner suing on his own behalf, but suing on behalf of the House of Representatives. So he may well succeed in at least that first critical threshold of getting standing.
Let's roll the clock forward. Imagine that the Supreme Court agrees with the D.C. Circuit and the law is enforced as it's stated, which is that the states must establish the exchanges. And so the governor wakes up one morning and he signs a decree that says, I hereby establish the exchange and I hire the federal government to run it for me for $1 a month. Problem solved.
That's right. But remember, there may have been some number of the refusing states. By the way, we have to make clear, Congress expected no state.
Yeah, it was a surprise.
It was a surprise that 36 states
36 states have never turned down highway money.
And so some of those states may have been misled by the IRS rule that said, hey, no matter what you choose, the money is coming to you, and maybe they chose that status after the rule.
So they can recant very easily.
Yeah, actually, I suspect states on each side can recant here. But other states, I think, very deliberately realized, however much money we're being offered, there's a lot of red tape and a lot of huge penalties for employers in our states and for employers who might think about coming into our states. And so we're going to turn down this whole package and we're going to try and encourage economic growth that way. One thing to consider here is the fact that it's this provision that in large part has resulted in this nationwide trend of employers pushing employees out of full-time work into part-time work. And for those who are concerned about what the lack of subsidies might be for the poor, I suggest the incentive to push people out of full-time into part-time status is probably one of the worst things you could do for the poor in this country.
Well, you're creating more of them. Which is nice. Great if you're trying to build your constituency to win an election. So there's really a method to the madness. So what you're saying is that if the Supreme Court rules in favor of the district court, upholds the law as written, some of the governors can recant and just declare that I establish it, here's $1 to the feds, and there might be some holdouts. And those holdouts would then what? Allow Obamacare to collapse within their states?
They would nullify the subsidy provision. Now, for people in those states that stay refusing, I do not think the IRS is going to come after them trying to collect the subsidies that they may already have gotten. I think the IRS has leeway to let bygones be bygones, even if they're
unless they want to pick a fight.
Yeah, I'm not sure they want to pick a fight over this. I think they're busy enough fighting on other fronts. They have all these hard disks to erase and have crash. And so I think you'll end up with at least some states sticking to their guns on this. And then it's going to be an interesting comparison. How do states do that are participating with exchanges versus how are refusing states doing?
And is this not the beginning of the complete breakdown of the rule of law as we go forward?
Well, if the Supreme Court were to go the other way, if they were to overturn the D.C. Circuit and instead say, we're going to pay less attention to the text, more attention to what we can somehow or other divine as being the intention of Congress.
The intent is goodness, and so therefore we vote in favor of goodness. You can do that with any statute you want.
Then I think, we're in big trouble, especially because, just going back a bit, it's always dangerous when agencies are allowed to ignore the statutes. I mean, remember, their function is to carry out the law, not to rewrite it. It's especially dangerous now, I think, because you've got an administration dead set on pushing its regulatory activities, its regulatory mission to infinity and beyond. And if in that sort of atmosphere you lift this restriction on the agencies, there's no telling what's going to happen.
Well, I mean, it's a continuation of what we've experienced. We've been under a living Constitution for many decades now, and I think that's pretty much the law of the land. The Constitution changes with the will of the people, and we'll move to living law. And that is something that we'll have to deal with, and whatever the president says is the law.
I don't think, for all the talk of living Constitution, things are anywhere near that bad. I mean, the Constitution's text still commands a lot of attention from judges, and I think it still receives a lot of that attention, regardless of what political party was in control when that judge came into office. So frankly, I don't think things are that bad, but I do think this is one key decision. And one thing I draw, some encouragement from is the fact that the Fourth Circuit, which ruled against us, which did get into this whole three-legged stool stuff, itself conceded that the arguments we were presenting were almost as persuasive as those of the feds, especially when it came to the language of the text. That, I think, is a very useful statement in that circuit for us.
So, Sam, this is a very complex set of cases. What's your outlook for the future?
Overall, I'm optimistic. They will no doubt be reconciled, and I think they'll be reconciled in a way that upholds the D.C. Circuit. And I say that based on a number of things. First, we do have this very new, embarrassing 2.5-year-old set of videotapes regarding Jonathan Gruber. Exactly, where the founder of the three-legged stool metaphor seems to be, in retrospect, suggesting that's a defective stool. It ought to be recalled. Secondly, you've got the Fourth Circuit itself sort of conceding that our arguments are very, very strong. And finally, I think the Constitution is going to prevail here, and that just like the framers did in the D.C. Circuit case, when it goes to some higher level, they're going to have the last word again.
Well, Sam, it's always good to have hope. Thanks for being on the show.
Thank you.
That was Sam Kazman, General Counsel at the Competitive Enterprise Institute, here on Real Clear Radio Hour. I'm your host, Bill Frezza. Ahead, Frank Buckley, author of The Once and Future King, The Rise of Crown Government in America, describes the evolution of the American presidency into a form that would be hardly recognizable to our founders. Stay tuned.